Hello everyone, Kia koutou katoa. My name's Gordon Anderson. I'm a professor at the law school, and today we're having a presentation looking at the impact of the COVID-19 crisis on a number of areas of domestic law. This will start with me talking about employment law, then my various colleagues who are here today will talk about the impact on a number of other areas of law. Following me, Māmari will talk about social welfare law and how that will be affected by the crisis. She will be followed by Ruiping Ye, who will talk about tenancy law and I think particularly the impact on residential tenancies. And finally, Victoria Stace will talk about insolvency law. So what we're hoping to do is give a little bit of a picture of how the law is affecting particularly working people and small business people and individual traders. So first, me on employment law. What I want to do today is look at how employment law is reacting in the crisis and the extent to which it may or may not prove resilient in dealing with some of the legal problems that will arise as a result of the economic pressure on employers and on employees generally. I probably want to look at about four things. Excuse me for glancing up and down at my notes, I'll put them down here. The first is just a general comment on the challenges being faced by employment law. I then want to move on to stress the fundamental point that employment law remains in place during the crisis and that therefore, of course, the protections for working people embodied in that law still continue to apply. I'd then like to make some comments on the particular problems that arise around either making people redundant or on trying to reduce terms and conditions of work, and in particular, pay cuts and conditions of that type. And finally, I would like to make a few points about how employment law may be impacted in the future and some of the consequences that may follow. So first, looking at employment law generally, New Zealand has a reasonably robust set of employment law protections in place for workers. But these, of course, have not been subject to the type of crisis we have at the moment and the extremely strong economic pressures that are existing for many businesses and for working people generally as well. Probably the most important point is that the fundamental protections of law, in particular the minimum code, remains in place. People remain entitled to the minimum wage. The Wages Protection Act still applies so that people are entitled to be paid on time and to be paid the full amount to which they are entitled for any pay period. And a number of protections in the Employment Relations Act also continue to be in force. And I'll discuss some of those more as we go through the presentation. The key point, however, is whether the protections can actually be enforced by working people at a time like this. Access to justice is tricky at the best of times, and it's particularly difficult, of course, for people who are relatively low paid and don't have the financial resources in order to enforce their employment rights. And this particular problem is likely to become even more aggravated during the crisis. That is, you may well have some employment rights, but whether you can effectively enforce those, particularly individually and without the help of a union, is problematic. It's also worth remembering that the key protection for most workers is the ability to bring a personal grievance. And in order for an employer's action to be shown unjustified, it has to be an action that a reasonable employer would not have taken in the circumstances of the case. Exactly what the circumstances of the case are and how the employment authority and the courts will react to what is reasonable is yet to be determined. But one might expect that employers will get somewhat more sympathy than they might normally get in relation to some of the actions they might take in response to the crisis. And additionally, remedies may not be particularly significant, particularly where employers are under very heavy financial pressure. But that is something we'll have to wait and see when the cases start coming. The second key point relates to the reduction of terms and conditions of employment. The fundamental point of contract law generally is you can't unilaterally change a contract of employment. You need the agreement of both parties to do so. And in the case of individual employment contracts, there are quite clear processes that have to be followed. In particular, employees have to be given notice of the proposal for a change, and they have to be told of and given time to consult about that change, to get advice on it. Whether this is happening in every case is unclear, and obviously quite considerable pressure is being put on some employees to agree to change terms and conditions, possibly without these protections being fully observed. Secondly, if a person is covered by a collective employment agreement, there are somewhat stronger protections in place. And as usual, of course, in circumstances such as this, if you're a member of a union, you're likely to be somewhat better protected than otherwise. But the key protection there is that the terms and conditions can only be changed by agreement between the union and the employer, and also that the workers affected have to ratify any agreement or changed agreement. That, of course, makes things considerably more difficult for employers. So, and the need in those cases for information to be provided for proper negotiations to take place, of course, may not prevent change in the longer term, but does slow it down. In the case of redundancies, there are also quite clear protections, and it appears that in a number of cases reported, these don't seem to be being fully implemented. The most important is that people whose jobs are going to be made redundant are entitled to be consulted about the need for redundancies and to be given full information about it and a chance to respond to that information. The information requirements are reasonably onerous if enforced, and it's become clear that a business decision has to be one that an employer might reasonably make. In the absence of information, it's difficult to argue that the business decision is fully justifiable, and obviously in future cases that may well be challenged. The other key point I think that needs to be kept in mind is that there is an underlying principle in the Employment Relations Act that all employment relations have to be carried out in good faith. This strong statutory obligation still applies during the crisis, and it means not only can the parties not mislead or deceive each other, they actually have to be proactive in dealing with each other. The good faith obligation is one that possibly is underestimated and one which again may improve in the future. Coming to the future, there's always the saying that a good crisis should not be wasted, and it is likely that there may well be pressure on the government and generally to reduce terms and conditions of employment in later reforms. In particular, there are strong arguments being made, well, there are arguments being made, I wouldn't call them strong, by the Employers and Manufacturers Association that effectively would make it much easier to dismiss people, particularly in the case of redundancy. This type of argument is also being picked up by the Productivity Commission in its most recent report on the future of work. There are arguments, of course, that should properly be resisted, as in fact it's not very difficult to sack people in New Zealand if they're redundant, and the protections, both in terms of doing that and consequentially, are relatively limited. But what is seen as part of these is the idea that basically while employees should be easy to be sacked, made more flexible and have the opportunity to move around in life, there should be some sort of social insurance assistance available to them. And it's that point, I think, that we move to Māmari to hear about the impact on the social welfare system. Māmari.
Kia ora, Gordon. Thank you for that beautifully done segue. Ka nui te mihi kia tātou katoa. Ko Māmari Stevens tōku ingoa. Ka nui te mihi. So my job today, I think, is to make a few observations about the social security system. And of course, our social security system, or our broader welfare system, incorporates aspects of social insurance. And I won't really touch actually on social insurance, except at a couple of little spots. I'll focus mainly on social assistance. However, there is some definite crossover there. And I guess before I start, I just wanted to make a point that, you know, when we're dealing with social security and the provision of assistance to people in need, which is what our system does, that there are a lot of people who are really struggling. And the pool of people who are really struggling has become far greater than it was just a couple of months ago. Just looking at statistics over the course of the first week, for example, of the week 4 lockdown, there was a 400% increase in emergency applications. There have been many, many thousands of people seeking aid and support through food banks, which operate outside of the social security system. And so there's just needs, I think, to be acknowledged that there are kind of human stories that show the cost of the situation that we're going through at the moment and the huge economic pressure that so many of us are under. And I also want to acknowledge too, by way of a preparatory observation really, that we do actually have a welfare system that has very long fingers. It has a lot of reach into a lot of different corners in New Zealand society. So New Zealand, for all that we can not infrequently moan about the heavy and bureaucratic nature of our welfare system, the flip side of that is that it has that reach. And so unlike other communities and other states and other countries where they're having to actually create distribution systems on the fly or try and patch and repair systems that were never designed for the pressure that they're under now, ours has not been under the same, we don't have the same degree of problem. There is, however, operational stress. So I do want to, and I'll come back to that point, but I'm mindful of the situation, for example, in a place like Florida, where its unemployment insurance system is kind of unique to the state and very, very over capacity at the moment. Something like only much less than half of its unemployment insurance claims have been able to be met since the beginning of this period of pandemic measures. So, you know, we don't have that kind of problem in New Zealand. So there is that's not to say that there aren't problems of distribution and reach, but our broader system makes that reach more possible, I think. I want to concentrate on a couple of duties, well, really a couple of principles that underpin the social security system, and then a couple of duties that are incumbent on the government as a result of those principles that are set out in legislation. I won't go into too much detail, but how those duties have been relaxed in a couple of key ways. So probably if you were to name the most important principles underpinning our social security system, unfortunately, community wellbeing would not be one of them. However, well, not one of the strongest. It's kind of there as a poor cousin, but really what our system is built on are two primary principles with a few others. And one is that you must demonstrate need in order to be able to get assistance in the vast majority of cases. Universality in our system is very limited, only to basically superannuation and things like well, no, pretty much superannuation and a couple of other bits and pieces. And also another key principle that our system really holds to is that work is determined to be the pathway, the best pathway to well-being. Now that's been placed in policy and legislation a lot more in the last 20 to 30 years. But make no mistake, that has been part of our social security system since its very roots. Even 19th century roots, you can see that kind of thinking present. So out of those principles arise a couple of duties that are incumbent upon the government and also supported in legislation. And one of those duties is the duty upon the state to provide active assistance. So, for example, Section 298 of the Social Security Act 2018 sets out a particular duty as a part of that duty to actively assist, to find out information about beneficiaries in order to match them up, presumably with the best entitlement or the most appropriate entitlement for that person. Now that's an outworking of that particular duty that's incumbent on the state. There's also another duty that's held in tension with that, and that is, well, not really held in tension, but there is some tension sometimes between them, and that is the duty upon the state to provide, to protect the public purse. So on the one hand, the state it's incumbent upon the state to provide active assistance to get the right amount of need support to the right person in recognition of the defined need. On the other hand, the state is under a duty to also protect the public purse. So these two pressures can be in direct conflict sometimes. Now, the interesting thing about this situation is that there has been some relaxation, for example, of both in a way. So when the epidemic preparedness notice of the 24th of March was released, if you go and check the wording of that notice, you'll see that there is some provisions, or that notice makes provision for certain key provisions of the Social Security Act to be unlocked. And one of those provisions is Section 64, to allow the government to grant emergency support to people who may not otherwise be entitled to it. So there is a kind of a lifting, or not a suspension, but certainly a lifting on those kind of directives to protect the purse strings of the government. But at the same time, that's also a slight relaxation on the directive to know exactly the amount of need that a person has in order to be provided with assistance. 17-year-old, just hang on a second. Great. So there is a slight relaxation in that work and income, as the operational arm here, does not have to inquire to the same degree that they would ordinarily have to do. And therefore, there's less of a kind of evidential requirement, if you like, for want of a better phrase. And at the same time, that means that there's a slight relaxation on this presumption and duty that the state is going to guard its purse strings come what may. So there was a little bit of that going on. So while the system is certainly operating as business as usual, because we've got the system in place, there are some things where you can see a relaxation. Another example of that is the regulation has been changed to allow for the suspension of stand downs, or the exemption from stand downs, which is another key mechanism in ensuring that the state is absolutely sure of entitlement and the need for that entitlement before it doles out the money for that entitlement. So there's another example there. Yeah, and actually Section 299 now has been on, in the Social Security Act, says that claims can be met without complete evidence of need. So that's just another example where those things have been relaxed somewhat. There are some interesting, there are things that we require vigilance for, I think, in the context of Social Security. So, for example, we all know, or we might remember, that benefit rates were raised by $10 per week, well, kind of average of $10 per week per person. And we were told at the time that that rate increase was permanent. However, just for us to remember that it was actioned by an order in council, and in the order in council there's a sunset clause which says that this will disappear if it's not legislated for by the operation of that sunset clause in mid 2021, I think. So there's some degree of vigilance, I think, that needs to help to happen in order to hold the government to account on things like that. And I just would make a note too that, you know, administrative discretion is a really important part of social security, even though some of that's been drained out of the system and kind of the reforms of the last 20 to 30 years. It's still a really important part of social security, and just there's increased use of discretion and probably relaxed surveillance on how that discretion is being used. And the usual controls on the exercise of that discretion. So there's some things to be looking out for. And this will be the husband. Hi, I'm on Zoom, darling. Also, just a point about wage subsidies, because wage subsidies are administered by work and income. However, they are not creatures of the welfare state, right? Those subsidies are government grants. And in fact, just to call back to this idea of social insurance, they are counted, it seems, as compensation under the Income Tax Act 2007. And there are things like there's no right to review on the grant of wage subsidies. So that although work and income is deeply involved in the administration of wage subsidies, they are not a creature of the social security system, so they don't have the same protections in place that beneficiaries would under the social, and non-beneficiaries in some respects, in terms of being able to have reviews and appeals on decisions and declinatures, for example. Just a couple of final observations, and I made this observation at the start too, is that we've got this, we have a good system in the sense that it's operating, doing what it should, but there is operational stress. So we do know that there have been occasional collapses of my MSD, hours where people can't get in to be able to make their applications online. So we do know that there's often a gap between the operational capacity and the need that's there. Not as severe as we see in other places, but there is still a gap. And the second point I'd make is one that can't be explored too much further here, but just to say that there's some interesting observations to be made about the public discourse about welfare, right? So wage subsidies, for example, they're not a creature of the welfare state in the sense of the Social Security Act, at least. But certainly the discourse around who deserves the wage subsidy, the deserving people who get the wage subsidy, as opposed to, you know, some of that ongoing discourse we've seen for many years now about beneficiaries who are not in the same kind of deserving camp. So even though we are all under stress, and even though there's many more of us that have this demonstrable need and require government assistance, we do still see a continuance of that deserving / non-deserving poor motif that we see a lot in New Zealand society. So it's worth keeping our eye out to see how that develops as well. But I'm going to leave it there now, Gordon. I hope that's not taken up too much time. Kia ora tata.
Thanks very much, Māmari. And yes, next we have Ruiping, who will talk about where you live.
Thank you, Gordon. Thank you. Yeah. Kia ora, everyone. I'll briefly talk about responses to residential tenancies and commercial leases during COVID-19. The government acted very quickly concerning residential tenancies. On 25th of March, that's the day before New Zealand went into lockdown, the COVID-19 response urgent management measures legislation bill was introduced, passed, and came into effect, all in the same day. The new act contains amendments to the Residential Tenancies Act, a new Schedule 5, provisions relating to outbreak of COVID-19 is added. The effect of the amendments could be summarized in one word, and that is to freeze. The amendments freezed tenancy relationships and freeze rents. For an initial 3 months and potentially a further 3 months, landlords are not allowed to terminate tenancies except in limited circumstances. Those circumstances are mainly to do with tenants, such as when tenants want to terminate, tenants have certain types of bad behavior, or tenants abandon the premises, or a sole tenant dies. The restriction on termination of tenancies has retrospective effects. Termination notices already given has no effect. Tenants could choose to remain in premises despite having given notice, or obtained order for termination, or agreed to terminate. There may be consequences. For example, landlords may have entered into a new tenancy agreement in anticipation of the termination of the existing tenancy. The law says that incoming tenants have no right to occupy the premises, and the obligations in the new tenancy agreement have no effect to either the landlord or the new tenant. The primary consideration, as explained in the Bill Digest and noted in the third reading of the bill, is to prevent people from becoming homeless if they were evicted. In practice, it also helps to maintain the lockdown situation, as it corresponds to requirements that people stay in the same house for the duration of the lockdown. The second effect is to freeze rents. Landlords are not allowed to increase rent for 6 months. This provision is again retrospective. If before the amendment a landlord had given notice for rent increase, but the notice had not taken effect, the notice has no effect. Landlords who knowingly try to terminate a tenancy beyond those prescribed circumstances, or knowingly try to increase rent, could be ordered to pay up to $6,500 of exemplary damages. Freezing tenancy relationship fits with the pause mode we are in during the lockdown, and most landlords will probably refrain from increasing rent on their own accord as a gesture of kindness and helping each other out in an extremely difficult time for many. The gravity of the pandemic threat and the temporary nature of the provisions were also justifying factors for the amendments. But the government's swift action regarding residential tenancies is a contrast to its reluctance or slowness to intervene in commercial leases, which have equally, if no more, significant impacts on the livelihood of ordinary people. Parties to commercial leases, so they face different challenges. Because of the lockdown, many businesses, and many of them are small businesses, have to be closed, which means that there is no income. The question is, what will happen to the tenants who could not afford to pay the rent? During the level 4 lockdown, the government announced its intention to amend the Property Law Act to extend deadlines for commercial lease terminations once Parliament resumed, and the Parliament resumed on 28th of April. So this is a step behind similar changes to residential tenancies. The period for rent arrear before a residential landlord could apply to the tenancy tribunal for termination was extended from 21 days to 60 days in the late March amendment to the Residential Tenancies Act. And the government plans to likewise extend the deadline for commercial lease from 10 days to 30 days when the Property Law Act is amended. But that is not all. Another question is, if the lease continues, Who should bear the financial burden of the lockdown? Thanks to a new edition of the Auckland District Law Society, the ADLS, template deed of lease, which was adopted in 2012 after the Canterbury earthquakes, some tenants are protected, but only to some extent. The 6th edition of the ADLS deed contains a clause which says that if there is an emergency and the tenant is unable to access the premises, then a fair portion of the rent and outgoings shall cease to be payable during the period when the tenant cannot access the premises. What does a fair proportion of the rent and outgoings shall cease to be payable mean? Lawyers quickly come to consensus that it does not mean deferral or of rent payment. It means rent abatement, so reduction of rent. The question is, how much is a fair proportion? Some details, things reported by the legal profession and the media, indicate that the practice varies significantly across the country, depending on many factors, including things like the nature of the premises and the parties' bargaining powers. And those tenants whose lease agreements do not contain a similar clause will not be protected and have to negotiate to vary the lease. Landlords can refuse to give concessions, and the tenants are without protection. Some landlords, as reported in the media, even argued that the premises is legally and physically accessible because the lockdown order does not preclude access to the specific premises. And the fact that tenants are confined in their homes by the lockdown does not mean the premises is inaccessible. If landlords and tenants could not agree and the government does not intervene in the rent payment issue, we may see the argument about accessibility ending up in courts eventually. Professional judgment and practical wisdom are called for, where there is no legislation or case law on this issue. Leading property lawyers caution that under the current circumstance, the right question to ask is not what the contractual right is, but what the consequence of insisting on the contractual right may be. The government had been reluctant to intervene, and the Justice Ministry's guidance for commercial leases during COVID-19, which was issued in mid-April, used soft words like landlords are encouraged to consider the tenant's situation. But not all landlords and tenants could reach a fair agreement. So as the situation continued to develop, it seems that the government finally decided to intervene. It is worth noting that countries like Australia, UK, and Canada have all taken steps to protect commercial tenants. So in a release on 29th of April, the Justice Minister indicated that the Property Law Act may be amended to require rent concession where the response to COVID-19 has had a material impact on a business. This will be a welcome relief to commercial tenants, but the details are yet to be seen. And that's me. Thank you.
Well, thank you, Ruiping. And finally, Victoria will deal with what I suppose is the other side of redundancy if you're a small businessman or a sole trader, that is insolvency. Victoria.
Thank you. Tēnā koutou katoa. I'm Victoria Stace, and I'm going to talk briefly about what has been happening in the insolvency law area. At the beginning of April, the government announced some tweaks to insolvency law to assist companies that are in financial distress as a result of the lockdown with a view to helping keep businesses afloat if possible. Many businesses are facing uncertain times. They've had reduced or possibly no revenue coming in during lockdown at level 4. And for many businesses, level 3 has not seen a return to normal trading. I'm not talking about supermarkets, obviously, but some restaurants, hairdressers, many retail stores, and others such as those in the tourism industry have been particularly badly affected. So under New Zealand's company law, there are certain duties placed on directors which, if breached, can lead to those directors becoming personally liable for the company's debts when the company goes into liquidation. Under that law, if the directors of a company that is in financial distress decide to keep trading on, and the company thereby incurs greater debt as a result, they can end up having to pay their own money into the pool of assets available to pay creditors when the company later goes into liquidation. There are two main duties at issue here. Firstly, Section 135 of the Companies Act, which relates to carrying on a business. So this section says that a director must not agree to the business of the company being carried on in a manner likely to create a substantial risk of serious loss to the company's creditors. Secondly, there's Section 136, and this relates to incurring new obligations. This section says a director must not allow the business to incur an obligation unless the director believes on reasonable grounds that the company will be able to perform the obligation when required to do so. So these provisions are intended to force directors to take a good hard look at the likely future prospects of the company if it's in financial trouble, and to cease trading if it looks like the company is going to fail, or otherwise take action to avert that failure, for example, reduce debt somehow. Otherwise, they can be personally liable for the increase in debt to creditors after that point. So many businesses are currently facing an uncertain future. They're not knowing when, if ever, things will return to normal. And meanwhile, debts continue to be incurred, rent, for example. And the prospect of having personal liability for the debts of the company can lead directors to deciding to close the business down when it could have recovered. So the law change is intended to avert precipitous action. What the government's decided to do is introduce a safe harbour for directors for breaches of sections 135 and 136. Under the new law, directors' decisions to keep on trading and decisions to take on new obligations over the next 6 months will not result in a breach of section 135 or 136 if certain circumstances are present. Those circumstances are, firstly, in the good faith opinion of the directors, the company is facing or likely to face significant liquidity problems in the next 6 months as a result of the impact of COVID-19 on the company's creditors, that the company was solvent, in other words, it was able to pay its debts as they fell due on the 31st of December 2019, and finally, that the directors consider in good faith that it is more likely than not that the company will be able to pay its debts as they fall due, in other words, it will be solvent within 18 months. For example, because trading conditions improve, or the company's going to be able to reach an agreement with its creditors. And I understand that the start date for those conditions is the 3rd of April. So in other words, the law is going to have retrospective effect as from the 3rd of April. And if those conditions are present, then the directors won't face personal liability for debts if it keeps trading on. And Australia and the UK have put in place similar measures. The aim here, of course, is to encourage businesses to keep going to minimise disruption to the economy, at least if the business is otherwise sound. The other important insolvency-related measure that will be introduced is that businesses affected by COVID-19 will be able to place existing debts into hibernation until the business is able to start trading normally again. So under this law change, companies, trusts, and partnerships will be permitted to enter into a moratorium on enforcement of debt. And this is intended to encourage directors to talk to their creditors with a view to possibly putting together a simple proposal for putting those debts into hibernation. To access this moratorium, the directors will need to decide that the company meets a certain threshold. We don't know what that threshold is yet, we haven't got the details, but it's likely to involve being solvent prior to COVID-19, having the prospect of returning to normal trading in the future, and hibernation being in the best interests of the company and its creditors. So what will happen is the directors can notify their creditors that they intend to trigger a 6-month moratorium. That notice triggers an immediate 1-month moratorium, and then the creditors get to vote. If 50% or more in number and value of creditors agree, then the 6-month moratorium is put in place. If that 50% voting threshold is met, all creditors are bound by it other than employees, and no creditor can enforce their debt for 6 months. And I think this will include secured creditors. The directors will retain control of the company, so they will not have to pass possession over to an insolvency practitioner. So certain other new measures are aimed at allowing the company to continue to trade during that 6-month moratorium and to be able to make payments to creditors who supply goods and services in the usual way. It's not clear at this stage if entry into a moratorium will be a trigger for creditors to exercise rights under other contracts, like, for example, terminating a lease. In practice, directors will have to put a proposal to creditors to get their agreement to this moratorium, and that's going to require directors to think about what steps they can take to mitigate the effects of the lockdown. For example, taking government wage subsidies and maybe trying to negotiate a rent abatement. So those are the main insolvency law changes proposed. That hibernation scheme is not available to sole traders, and it is also not available to insurers or banks. And other directors' duties will remain in place. For example, the duty to always act in good faith and the duty to exercise care, diligence, and skill. And of course, the other options to negotiate arrangements with creditors that already exist under the Companies Act will remain. For example, the option of a creditor compromise or voluntary administration. A lot of the detail is still missing. We won't know that detail until the legislation is available or more details are made available to the public. The latest information is obtainable from the Companies Office website, and that was posted on the 3rd of April. I suggest these are useful and thoughtful changes to insolvency law, but they're fairly minimal interventions, and they're not likely to prevent many businesses failing as a result of the lockdown. There are a number of other incidental changes that are going to be made. For example, allowing the use of electronic signatures, giving the registrar of companies the power to extend deadlines, for example, for filing annual returns, giving companies relief if they can't comply with constitutional requirements, and delaying the start date of some insolvency-related law changes. So thank you very much. That's all I wanted to say about insolvency law.
Thank you very much, Victoria. And hope anyone watching this enjoys that and gets a few insights from it. So thank you very much, and it's goodbye from me and goodbye from them. Thank you.